Good morning, Your Honors. Welcome to Northampton. On behalf of Mr. Montgomery, I'm going to ask the court to do two things today in this case. First, I'm going to ask the court to put an end to these so-called CSI questions. The court has been troubled ever since its first decision concerning these type of questions in 2010. And in Judge George's decision in 2022, we came right to the line, but yielded to the judicial discretion. The questions, the so-called CSI questions, as the friend of the court brief put it so eloquently, was a solution where there was no problem. So that's my first ask. My second ask is based on the manner in which the deliberating jury was chosen, created an unfair, impermissible jury that was unfairly skewed to the Commonwealth and actually reduced the burden of proof that the Commonwealth had to prove. And the problem that caused, the solution to that problem, is for Mr. Montgomery to get a new trial.
Counsel, before we go too far in, you don't really grapple with the footnote in the appeals court decision, and I'd like to, at least as a threshold matter, figure out whether or not you had to determine or demonstrate bias in order to raise this issue. Because the case that the appeals court cites, the Hampton case, that talks about you can't just say in the process, if you're going to claim structural error, you've got to demonstrate bias. And do you have to show bias in this case?
I don't think so, Your Honor.
And why not? Because just specifically about that case, it says you can't point to irregularities in the process of picking the jury to demonstrate bias. And it seems like that's exactly what you're saying here.
Well, what I was thinking of is actually the Commonwealth's brief when they cite to the Van Long case.
Mm-hmm.
And the Van Long case held specifically that if a single member of a deliberating jury was not fair or impartial, that really ends the discussion. And under Van Long and at page 32 of the Commonwealth's brief, the defendant's entitled to a new trial. Our view in looking at this process, and mindful of the court's instructions in the Williams case, is that each and every time a potential juror came to sidebar, they were removed systematically if they voiced two concerns. Mm-hmm. One, the lack of forensic evidence, and then subsequently, after the judge instructed the Commonwealth to at least tell the potential juror that there would be eyewitness testimony that this court has recognized is somewhat problematic. Mm-hmm. Could they and would they convict? And it's really the use of the word convict in the Montgomery case which distinguishes it from the court's prior holdings in Gray, in Perez, and in your case, the Brown case in 2022.
So if you go back for a moment, you said something that I think is important. So in your view, the defendant doesn't have to demonstrate any prejudice here at all?
I don't believe he does.
Okay.
I believe it's simply that the process crossed the line and you had a deliberating jury that was chosen in such a manner that the impact raised due process concerns because it lowered the burden of proof that the Commonwealth would have to prove.
The same standard of review, whether or not the defense attorney objects?
Say that again. I'm sorry.
Standard of review. It doesn't matter if the defense attorney objects.
Well, we know there was no objection.
Right.
That's why I'm asking you the question.
Right. The point I'm making.
So what's the point of an objection then if the defense attorney sat on his hands or her hands?
Well, the problem is that on the
It doesn't
second juror.
It doesn't alert the judge to the problem. That's why we have objections.
I think the issue is there's two ways to answer this question. One, I think given the sidebar communication set forth in the record, that any objection would have been futile since it was the judge who, told the Commonwealth that when they're asking questions of the potential jurors, that they should at least be told.
It seems to me the issue in this case, or the problem in this case, and again, I'm a proponent of it, but as attorney voir dire, because when the judge is asking questions, the judge can craft those questions to get out that impermissible language. Here we see examples of kind of free-flowing attorney voir dire, where the prohibited phrase is slipped in sometimes, but not other times.
I mean, I think it was one of your cases when you were a trial court judge where you at least asked the question that when there was some concerns raised by a potential juror about whether or not the fact that there was a lack of forensic evidence was going to be a concern to them, you said, well, I don't know if you used the word despite, but would that prevent you, however, from being, and then using the language of Williams.
As long as you say fair and impartial, you're basically immunized.
And once you use that, I mean, those are words that this court has instructed in Williams. I mean, when Judge Budd wrote that decision, the court was acknowledging that there had been some muddled communication about what should or should not be said. So after Williams, we have a pretty clear indication that the mere fact that somebody brings, I think the language in Williams was, their worldview, that they look at things through a certain world. That's not what happened in Montgomery.
So as far as the standard review goes, along the lines of what Justice George is asking, when we have, for instance, Batson Soares issues, and we have one prohibited inquiry, we say prejudicial, new trial.
Right.
Because we have one juror who's been infected. Here, what you're asking us to do is, where there's no objection and only one juror who's seated is asked about the ability to convict, you want us to apply the same remedy that we do in Batson Soares.
I do, and I don't think it was one juror as...
No, it's the hypothetical.
Oh,
right? So,
okay.
Yeah, so if it was only one juror, well, just like if there was one juror who had a bad, who was, where there was a violation of Batson Soares, that's all you need. You want us to have the same rule in this instance as we do.
I think it's warranted because, for two reasons. I think it's warranted, one, because there's no basis really to have these so-called CSI questions. We who practice in the trial court have been troubled by these questions for a long time. The court has been troubled. There's no empirical evidence that the CSI effect is real, and the normal Webster instructions and the normal regular way that a jury is impaneled would be sufficient.
What do we make of the fact that so very many members of the veneer actually answered the question affirmatively, though? There were a lot of potential jurors who said, yeah, I couldn't convict without forensic evidence.
I don't think it was ever quite that clear. I think what they said that they would have a reasonable expectation, and this sort of comes into that the juror who is like Williams, who brings their life experiences. So they bring their life experiences to the court. They say they learn that this is a murder case, and they think that they would expect to have some type of forensic evidence presented to them within the context of a murder case.
Well, we don't really know all of this. We can only speculate because the judge didn't follow up, which is part of your argument, I understand. But we're left with this question of, what do we do about prejudice?
Yeah, that's a big deal. Could you indulge us, please, and say that it's not structural and you do have to show prejudice, because there's an issue here with that.
Well, the question, I get it's a big deal, and I agree with you. I think what happened here, as you look at the way the deliberating jury was chosen, is that the burden of proof was lowered. The evidence was previewed. There were many times where the prosecutor said, well, there won't be forensic evidence, but on the urging of the trial judge said, but there will be eyewitness testimony. And then they got eyewitness
Well,
testimony.
let me ask you about that, because there's a specific reason why I'm interested in it. Because we're talking and we're using the CSI effect as if we're talking about all of these fancy, doodads and black lights and all of these other things. But that's not how the defense argued the case. And I'm going to point to you specifically the language that I'm speaking of. When the defense raised the issue about the Bowden defense, it wasn't about CSI effect. It was, and I'm reading from volume 5 at page 164. Mr. Brown, I did not make one. I would request the Bowden instruction in this case because I think the evidence suggests that the police, we only heard from, I think, 2 police officers. And as I understand it, there was a great number of witnesses who were identified, and the Commonwealth tried to present some evidence of that today. However, there's no evidence that the police sought out a number of these other witnesses who have been identified during the course of the trial, who the witnesses identified to the police prior to trial when they gave their statements back in May and when they testified back in June of 2018, Your Honor. And I suggest to the court that that's exactly what the Bowden instruction is for. So they are arguing for Bowden for failure to interview witnesses, not CSI. And at the very end, during closing, there's that one sentence where the defense says that you can't convict here because of lack of forensics. That one sentence, and spends the vast majority of what he's talking about, how the witnesses were inconsistent and can't be believed. Not about all of this CSI stuff.
I think they were intermingled in the voir dire. And the way the case unfolded at trial, the focus became on the lack of further investigation relative to other people who were in that, what was described as a chaotic scene at the child's.
How is that CSI?
It's not particularly. It's not. Where they came together is they came together in the voir dire, at least in my opinion, when the first question is being asked by the prosecutor, I think even in prospective juror number 1, is whether or not you would need forensic evidence, and that's when the judge interposed and said, well, unless you tell them there's going to be other evidence, specifically eyewitness testimony, it sounds like from your question, there is no other evidence. So from that moment on, the prosecutor's question at the sidebar when interviewing potential deliberating jurors mingled the eyewitness testimony evidence from that the judge had instructed, and with the forensic questions. So it's a little unclear. Is the CSI question allowed the prosecutor, based on the holdings of this court up until through 2022, to ask the question about the forensic evidence, but when the judge started listening to the interplay between the prosecutor and the potential juror, the judge instructed to at least add the eyewitness testimony.
But if we found prejudice if we found that you had to show prejudice, and then we went through the 4 factors of how prejudice manifests, and we talked about the nature of the error and the significance of the error, whether it was central to the trial, it wasn't tried that way. Don't we have to look at how you tried the case and the fact that this wasn't central to the defense? And the Bowden instruction was requested for the police not interviewing witnesses that potentially were available to be interviewed. So how do you go through the framework, the metric that we're going to use if we say you've got to demonstrate prejudice?
I think the answer to that question is they were told, they being the deliberating juror, they were all told before they were sat that there's going to be eyewitness testimony. And the judge essentially put his stamp of approval on that type of testimony. So as the friend of the court brief pointed out, the Gomes instruction 9 days later was really almost an afterthought. They were primed to believe that eyewitness testimony would be sufficient to convict, and there was eyewitness testimony. So that was where it mingled from the CSI question, which was, I don't know what was in the mind of the Commonwealth prosecutor when he began to ask that question, but it got mingled, and we had a deliberating jury sat that really confirmed two things. They confirmed, one, that they didn't need forensic evidence, because if they thought that they did, they were disqualified. And two, they had no qualms about convicting on eyewitness testimony, because if they indicated that they did, they also were disqualified. And under the circumstances, you had a deliberating jury of 12 that had pre-committed to convict on eyewitness testimony. And for that reason, I don't believe that the prejudice analysis has to go any further than it went in the Van Loan case.
Counsel, I have a question. You were going to give two reasons why we should treat this as if it were like a Batson Soares issue with the jury. You gave the first one, which was there's no basis in science as to the CSI effect. What was the second?
The second is that based on what was actually asked of these jurors, I would say there was 2 points I was going to ask you to do. One, to finally get to the point where you determine that these so-called CSI questions are unnecessary. And two, as applied in Mr. Montgomery's case, to give him a new trial with a fair and impartial jury.
You've got multiple eyewitness identifications here by people who know the defendant, right?
As was pointed out at the trial and in the appellate briefs that were filed both at the appeals court and in the FAR petition, many of the witnesses who were testified, I believe, were given cooperation agreements and lesser sentences. And that goes back to what Judge George was asking me about in terms of the lack of follow-up on other people at this birthday party.
It just seems like science is not the issue. Forensics is not the issue. Again, because we're not dealing with stranger ID. We're dealing with whether the IDs are manufactured from prejudice or vengeance, right? We're not dealing with science problems.
That's the way the case came out. Absolutely, I agree. It did not become an argument about the lack of forensics.
Right, so like the best case for prejudice would be a Bowden instruction or a Bowden argument, at least, where the defense is you didn't fingerprint, you didn't DNA, et cetera, correct? That'd be clearer prejudice.
I agree.
Okay, thank you.
Thank you.
Attorney Shepard.
May it please the court, David Shepard-Brick on behalf of the Commonwealth. Not only was this case only about eyewitnesses and not about science, but the trial judge in his decision on the motion for a new trial said that the evidence was overwhelming. And that the defendant says that these were...
If the case was not about science, why would you ask the jurors whether they can convict in the absence of science?
Because, and I think it's bared out in the jurors' responses to the question, is some of them said, for a conviction, I can't do it without DNA or fingerprints. And the concern was that, and I think their answers show, the ones who were excused show that it was a legitimate concern that, yeah, we're going to put on eyewitnesses who certainly had credibility problems on paper. The trial judge who observed them said they were very credible, and I would agree that I was there. They were, some of them were very credible.
So they're asked a hypothetical question that's probably looks improper, and then they're excluded because the way they answer the hypothetical question. It seems, don't we want to at least narrow down the kinds of questions you could ask? And this one crossed the line, right? You shouldn't be asking, can you convict?
I don't think that that's necessarily true. The court said in Andrade that just because a juror will could convict doesn't mean that they will. They're not. I agree that if you said to the juror, will you convict this defendant if we present eyewitness testimony, and they said no, and then they were kicked, then you have a problem because you were violating Rule 6. You're asking them to commit to a verdict. Here, it's asking, and I agree there probably could have been a better phrasing. It's usually asked as, would it affect your ability to be fair and impartial? Would you be able to hold the Commonwealth to its burden? But I don't think that it is necessarily improper to ask a juror if they would have trouble following the judge's instructions on reasonable doubt if there is no scientific evidence.
But that wasn't the question here.
No, that wasn't the question. And it could have been phrased that way and probably should have been phrased that way. But I don't think
So
that you
what
have...
are you defending the way that this question was asked?
I'm defending the way that these questions should be allowed to be asked in a certain form. And I
That's
think...
the current law. But what about this case?
So in this case, I think that the questions... I think the jurors' answers to the questions show that in this case it didn't have an impact. And
So that's a different issue, right? The questions that were asked by the prosecutor were improper.
I don't necessarily agree with that because I don't think that it violates the rule because they weren't committing to a verdict. They were asked if they would be able to if they found the other evidence compelling and credible.
So you don't concede when the prohibited convict word is used that's improper voir dire question.
I don't think that that there's the magic word that automatically makes it an improper question. I think it's probably a word that's better not used, but I don't think that it automatically makes it improper.
If they frame the combination of the judge's addition and the prosecutor's question frames it as, can you convict? Are you comfortable convicting in a case in which you're only going to get eyewitness identification? It really can't be a good formulation of this, right? We got to stop that question, don't we?
I mean, I agree that the question could have been better phrased. I don't think it was over the line, but I do think that in the future, it probably shouldn't get asked that way.
Okay, can we just talk about that for a second? So the question, as phrased to most of the jurors, was, can you convict with eyewitness testimony alone without forensics? The only intelligent answer to that question is, it depends, right? Because it depends on the strength of the evidence that is presented. But the question was not asked in any way that left that space. And so what we had were jurors who, some of them struggled with the question because the answer is it depends, and they were uncomfortable, and they responded appropriately and said, well, I don't know,
right?
Because it depends on what the evidence is. And then other jurors just went straight ahead and said, no, I can convict. So can you deal with those jurors, please?
So, I mean, I think that, which jurors? The ones who...
The jurors who did not see the nuance in the question and just went, yes, I can convict.
Well, and I don't know that they didn't see the nuance in the question, because what the trial judge said in his order denying the motion for new trial is, I watched all these jurors during the impanelment. None of them committed to a verdict. So the fact that one of them might have said yes doesn't mean they didn't pause, think about it, and go, yes. And I think that's
Let's
fine.
assume that we think the way the question was phrased was improper.
Okay.
Why not treat this as we treat bats and sores?
Because the having of this particular opinion is not particular to some specialized or protected group in the community. Having the belief that the Commonwealth must present CSI evidence would be I don't think the peremptory challenges here are at issue, because if the prosecutor asks the question and bumps them for a peremptory challenge, no harm, no foul. The question is whether or not a for-cause challenge is treated as an additional Commonwealth peremptory. And the great weight of authority, I think the DC Circuit is the only case that I was able to find. Everybody else has said that's the right of selecting of a jury is one of exclusion. You don't get to say, I want that juror. all you get to say is, I don't want that juror.
That's generally, I think you're absolutely right that in general, across the board, we assume that the jurors who are seated to replace the wrongly struck jurors are fair and impartial. But the argument being made here is that there was a systemic effect on the selection of this jury because they were all subjected to this question. So what do you think is the strongest, most analogous case for the proposition that there's no systemic effect here?
Well, I mean, I think it goes to, I point again to the Andrade case where the question was, the court said just because they say they can doesn't mean they will.
Well, that question was totally different because it built in the qualifiers about the burden of proof and so forth.
Correct.
I'm asking a prejudiced question about the question that Justice Wentland was asking, which is what is your best case for the proposition where all of the jurors were filtered through this question that all of them heard and only the ones who sort of passed the test were put on the jury? What's your strongest case for the idea that we should not, for the prejudice analysis here?
Well, I think it's Perez. I think it's Young. I think in both of those cases, you have similar questions, and so you're filtering everybody. You're asking in all of those cases, you're asking everybody the questions. So, and in those cases, you're not dealing with a situation where, because I think in Andrade it was just a couple of the jurors who were filtered through that question. But
it's a different question.
It is a different question, but the issue is answering that specific question. In the other cases, everybody was filtered through that question. So I don't think that necessarily creates a systemic issue. Also, you have a defense attorney who's in the room, who's hearing them say this, and isn't worried that they're committing to a verdict.
But is your best argument that Batson Soares is focused on discrimination, which is so we have a different, because normally if you waive, we move to substantial risk.
Right.
Your argument is, my understanding of your argument is, it's waived, so you're doing a substantial risk analysis.
Correct.
And you don't need to wrestle with whether this is comparable to Batson Soares because it's different.
Well, we're right. It's different from Batson Soares because I think in the case where, because I would argue that a peremptory challenge in this case, based on the answer to the question, doesn't get the defendant anywhere because you can use a peremptory challenge for any reason other than a prohibited reason.
Can I ask, and again, I should know this, but I don't. Have we extended the Batson Soares approach outside of protected classifications? Have we ever done that before?
Not that I'm aware of.
This would be the first case where we would move Batson Soares outside of the race.
Well, right, and that's you're in the Batson Soares analysis, you're protecting the right to a fair cross section of the community and the juror's right not to be excluded based on an immutable characteristic.
Your argument is essentially, okay, we do normal waiver analysis, and there's overwhelming evidence of eyewitness testimony that this person, by people who know the defendant, shot the guy in the head.
Correct.
Counsel, is that argument in your brief? I didn't see an argument in your brief that there was no substantial risk of miscarriage of justice because the evidence here was overwhelming. Was I just missing something that you seem to argue?
I did discuss it I think it was maybe one sentence because the judge found that the evidence was overwhelming and so it wasn't improper. There was no substantial risk.
On page 32 of your brief, you discuss the substantial risk of miscarriage of justice standard.
Mm-hmm.
And the way you discuss it is you say that the defendant must show he was actually harmed and must show that at least one juror seated was not fair and impartial. And unless he can show that, there's no substantial risk of miscarriage of justice. So you seem to have sort of narrowed the substantial risk of miscarriage of justice inquiry to just the question of, is there a substantial risk of miscarriage of justice because this jury was not fair and impartial? Do you think that is the inquiry, or is it the broader inquiry?
It's definitely the broader inquiry. I would say that it has to be, because that's the substantial risk standard is we look at the case as a whole, and we look at the way it was tried. And in this case, it doesn't. It wasn't tried as a you should have done these tests. It was a don't believe these people. One of them's a cooperating witness. One of them's been given immunity. That was the way the case was tried. So ultimately, I think when you take the holistic view, which is required under the substantial risk standard, you come to the result that there was no substantial risk.
I read what you were trying to do is to show there's no prejudice whatsoever. So
Right.
you don't have to get to the
Yes.
yourself. Yeah.
Right.
Which is a tough road to hoe than the simpler one, which is you got three persons who saw him shoot him in the head, and you don't have a bone to pick.
Right. I mean, yes. I think the point I was trying to make was simply that this question in some form is proper, and so that the court shouldn't simply just get rid of it because.
Counsel, could I just make sure I have your starting point? So are you saying as a starting point, asking this question wasn't structural error, but you've got to show prejudice? You're saying it's not structural error at all?
Yes, it's not structural error at all.
Okay.
If the court has no more questions, I'm happy to rest on my brief.